So I'll be reading some legal doctrines that are commonly used in the Philippine setting. And if you're not yet already subscribed, go ahead and hit the subscribe button and hit the notification bell so you'll get updated on my next upload. Thanks. Doctrine of absolute privilege. Doctrine that protects persons from claims alleging defamation where the alleged defamatory statements were made by members of legislative assemblies while on the floor of the assembly or communications made in the context of judicial proceedings as part of a trial. Doctrine of absorption of common crimes, also called the Hernandez Doctrine. The rule enunciated in People versus Hernandez that the ingredients of a crime form part and parcel thereof, and hence are absorbed by the same and cannot be punished either separately therefrom or by the application of Article 48 of the Penal Code. In Real versus Amin, GR 93335, September 13, 1990, it held that the crime of rebellion under the Revised Penal Code of the Philippines is charged as a single offense and that it cannot be made into a complex crime. Doctrine of Actio Personalis Moritur Cum Persona. It's a Latin word, the doctrine that personal action terminates or dies with the person. In the case of Santos versus Secretary of Labor, GR 21624. Doctrine of adherence of jurisdiction. The principle that once a court has acquired jurisdiction, that jurisdiction continues until the court has done all that it can do in the exercise of that jurisdiction. Number 2, the doctrine holding that even the finality of the judgment does not totally deprive the court of jurisdiction over the case. What the court loses is the power to amend, modify, or alter the judgment. Even after the judgment has become final, the court retains jurisdiction to enforce and execute it. Echagoray versus Secretary of Justice, also called the doctrine of continuity of jurisdiction. Next, doctrine of adherence to judicial precedents, also called the doctrine of stare decisis. The doctrine that enjoins adherence to judicial precedents. It requires courts in a country to follow the rule established in a decision of its Supreme Court. That decision becomes a judicial precedent to be followed in subsequent cases by all courts in the land. Philippine Guardians Brotherhood versus Comelec. Next is the doctrine of agency by estoppel, also known as doctrine of holding out. The doctrine where the principal will be estopped from denying the grant of authority if third parties have changed their positions to their detriment in reliance on the representations made. Doctrine of alter ego, a doctrine based upon the misuse of a corporation by an individual for wrongful or inequitable purposes, and in such case the court merely disregards the corporate entity and holds the individual responsible for acts knowingly and intentionally done in the name of the corporation. The doctrine imposes upon the individual who uses a corporation merely as an instrumentality to conduct his own business liability as a consequence of fraud or injustice perpetrated not on the corporation, but on third persons dealing with the corporation. Sulunang Bayan versus Araneta, GR 31061. Doctrine of apparent authority, the doctrine under which acts and contracts of the agent, as are within the apparent scope of the authority conferred on him, although no actual authority to do such acts or to make such contracts has been conferred, bind the principal. The principal's liability, however, is limited only to third persons who have been led reasonably to believe by the conduct of the principal that such actual authority exists, although none was given. In other words, apparent authority is determined only by the acts of the principal and not by the acts of the agent. Benater versus Philippine Countryside Rural Bank, GR 163825. July 13, 2010. It is also called the holding out theory or doctrine of ostensible agency or agency by estoppel. Doctrine of assumption of risk. The precept that denotes that a person who knows and comprehends the peril and voluntarily exposes himself or herself to it, although not negligent in doing so, is regarded as engaging in an assumption of the risk and is precluded from a recovery for an injury ensuing therefrom, also called doctrine of volenti non fit injuria. Doctrine of attractive nuisance. A legal doctrine which makes a person negligent for leaving a piece of equipment or other condition on property which would be both attractive and dangerous to curious children. These have included tractors, unguarded swimming pools, open pits, and abandoned refrigerators. Liability could be placed on the people owning or controlling the premises even when the child was a trespasser who sneaked on the property. Doctrine of bar by prior judgment. A concept of res judicata holding that when, as between the first case where the judgment was rendered and the second case that it sought to be barred, there is identity of parties, subject matter, and cause of action. In this instance, the judgment in the first case constitutes an absolute bar to the second action. Antonio versus Saiman, GR 149624. Doctrine of caveat emptor, also called the doctrine of let the buyer beware, a warning that notifies the buyer that the goods he or she is buying are, as is, or subject to all defects. The principle under which the buyer could not recover damages from the seller for defects on the property that render the property unfit for ordinary purposes. The only exception is that if the seller actively concealed latent defects or otherwise made material misrepresentations amounting to fraud. Doctrine of collateral estoppel, a doctrine that prevents a person from relitigating an issue. Once a court has decided an issue of fact or law necessary to its judgment, that decision precludes relitigation of the issue in a suit on a different cause of action involving a party to the first case, also called doctrine of preclusion of issues. Doctrine of command responsibility, the doctrine under which any government official or supervisor or office of the PNP or that of any other law enforcement agency shall be held accountable for neglect of duty if he has knowledge that a crime or offense shall be committed, is being committed, or has been committed by his subordinates or by others within his area of responsibility, and despite such knowledge, he did not take preventive or corrective action either before, during, or immediately after its commission. Next is doctrine of comparative injury, a rule in equity which states that although a person is entitled to injunctive relief, if the injury done to the respondent or the public would be disproportionate, then injunctive relief must be denied. Doctrine of comparative negligence, the doctrine that allows a recovery by a plaintiff whose own act contributed to his injury, provided his negligence was slight as compared with that of the defendant. Rakes versus the Atlantic, Gulf and Pacific, Tier 1719. That was a long time ago, January 23, 1907. Doctrine of compassionate justice, the doctrine that the harsh provision of law and the rigid rules of procedure may sometimes be tempered and dispensed with to give room for compassion. Doctrine of completeness, the doctrine holding that a dying declaration to be admissible must be complete in itself. To be complete in itself does not mean that the declarant must recite everything that constituted the res gestae of the subject of his statement, but that his statement of any given facts should be a full expression of all that he intended to say, as conveying his meaning in respect of such fact, People versus De Hoya, GR 75028, November 8, 1991. Next, Doctrine of Conclusiveness of Judgment, a concept of res judicata holding that where there is identity of parties in the first and second cases, but no identity of causes of action, the first judgment is conclusive only as to those matters actually and directly controverted and determined, and not as to matters merely involved therein. Stated differently, any right, fact, or matter in issue directly adjudicated or necessarily involved in the determination of an action before a competent court in which judgment is rendered on the merits is conclusive, settled by the judgment therein, and cannot again be litigated between the parties and their privies, whether or not the claim, demand, purpose, or subject matter of the two actions are the same. Antonio Simon de Monge, GR 149624. Doctrine of Condonation. The doctrine that a public official cannot be removed for administrative misconduct committed during a prior term, since his re-election to office operates as a condonation of the officer's previous misconduct to the extent of cutting off the right to remove him therefore. The foregoing rule, however, finds no application to criminal cases pending against petitioner Aguinaldo versus Santos, 212 SCRA 768, also called Doctrine of Forgiveness. Doctrine of Constitutional Supremacy. The doctrine that if a law or contract violates any norm of the Constitution, that law or contract, whether promulgated by the legislative or by the executive branch, or entered into by private persons for private purposes, is null and void and without any force and effect. Thus, since the Constitution is the fundamental, paramount, and supreme law of the nation, it is deemed written in every statute and contract. Manila Prince Hotel versus GSIS. Doctrine of Constructive Compliance. Doctrine which states that if, without the fault of the heir, the model institution cannot take effect in the exact manner stated by the testator, it shall be complied with in a manner most analogous to and in conformity with his wishes. Doctrine of Constructive Trusts. A general principle that one who acquires land or other property by fraud, misrepresentation, imposition, or concealment, or under any such other circumstances as to render it inequitable for him to retain the property, is in equality to be regarded as a trustee ex maleficio thereof for a person who suffers by reason of the fraud or other wrong, and is equitably entitled to the property even though such beneficiary may never have any legal estate therein. Magalon versus Montejo, GR 73733, December 16, 1986. Doctrine of Continuity of Jurisdiction. The general principle that once a court has acquired jurisdiction, that jurisdiction continues until the court has done all that it can do to exercise that jurisdiction. Doctrine of Corporate Negligence. The judicial answer to the problem of allocating hospitals' liability for the negligent acts of health practitioners, absent facts to support the application of respondeat superior or apparent authority, its formulation proceeds from the judiciary's acknowledgement that in these modern times, the duty of providing quality medical service is no longer the sole prerogative and responsibility of the physician. The modern hospitals have changed structure. Hospitals now tend to organize a highly professional medical staff whose competence and performance need to be monitored by hospitals, commensurate with their inherent responsibility to provide quality medical care. Professional Service Incorporated versus Agana, GR 126297, January 31st, 2007. Doctrine of Corporate Responsibility. The doctrine following which it was held that a hospital has the duty to see that it meets the standards of responsibilities for the care of patients. Such duty includes the proper supervision of the members of its medical staff. Professional services versus Agana. Doctrine of difference and non-disturbance on appeal. The doctrine that the Supreme Court on appeal would not disturb the findings of the trial court on the credibility of witnesses in view of the latter's advantage of observing at first hand their demeanor in giving their testimony. Tihanki concurring Lamaso versus Sandikambayan, GR 63408 and 64026, August 7, 1985. Doctrine of dependent relative revocation. Doctrine which states that a revocation subject to a condition does not revoke a will unless and until the condition occurs. Thus, where a testator revokes a will with a proven intention that he would execute another will, his failure to validly make the latter would permit the allowance of the earlier will. Doctrine of discovered peril. The doctrine holding that where both parties are negligent, but the negligent act of one is appreciably later in time than that of the other, or when it is impossible to determine whose fault or negligence should be attributed to the incident, the one who had the last clear opportunity to avoid the impending harm and failed to do so is chargeable with the consequences thereof. Pickard versus Smith, 37 Phil 809. See also last clear chance doctrine. Doctrine of disregarding the distinct personality of the corporation. The doctrine stating that when the notion of legal entity is used to defeat public convenience, justify wrong, protect fraud, or defend crime, the law will regard the corporation as an association of persons, or in the case of two corporations, merge them into one, and one being merely regarded as part or instrumentality of another. Utivo and Sons Hardware versus CTA. The same is true where a corporation is a dummy and serves no business purpose and is intended only as a blind or an alter ego or business conduit for the sole benefit of the stockholder. Doctrine of effective occupation. A doctrine in international law which holds that in order for a nation to occupy a coastal possession, it also had to prove that it controlled sufficient authority there to protect existing rights such as freedom of trade and transit. Doctrine of election of remedies. A doctrine developed to prevent a plaintiff from a double recovery for a loss, making the person pursue only one remedy in action. Although its application is not restricted to any particular cause of action, it is most commonly employed in contract cases involving fraud, which is a misrepresentation of a material fact that is intended to deceive a person who relies on it. Doctrine of equitable recoupment. It provides that a claim for refund barred by prescription may be allowed to offset unsettled tax liabilities should be pertinent only to taxes arising from the same transaction on which an overpayment is made and underpayment is due. Doctrine of equivalence. The rule stating that an infringement also takes place when a device appropriates a prior invention by incorporating its innovative concept and, although with some modification and change, performs substantially the same function in substantially the same way to achieve substantially the same result. Smith, Klein, and Beckham Corporation versus CA. Doctrine of equivalence test. A test established to determine infringement, which recognizes that minor modification in a patented invention are sufficient to put the item beyond the scope of literal infringement. Thus, an infringement also occurs when a device appropriates a prior invention by incorporating its innovative concept and, albeit with some modification and change, performs substantially the same function in substantially the same way to achieve substantially the same result. Godinez versus CA GR 97343. Compare it with literal infringement test. Doctrine of estoppel. A doctrine based on grounds of public policy, fair dealing, good faith, and justice, the purpose of which is to forbid one to speak against his own act, representations, or commitments to the injury of one to whom they were directed and who reasonably relied thereon. Doctrine of estoppel by laches, an equitable doctrine by which some courts deny relief to a claimant who has unreasonably delayed or been negligent in asserting a claim. A person invoking laches should assert that an opposing party has slept on his or her rights and that the party is no longer entitled to his or her original claim. Doctrine of executive privilege, the doctrine stating that a president and those who assist him must be free to explore alternatives in the process of shaping policies and making decisions, and to do so in a way many would be unwilling to express except privately. These are the considerations justifying a presumptive privilege for presidential communications. The privilege is fundamental to the operation of government and inextricably rooted in the separation of powers under the Constitution. Almonte versus Vasquez. Doctrine of exhaustion of administrative remedies. The general rule that before a party may seek the intervention of the court, he should first avail of all the means afforded him by administrative processes. The issues which administrative agencies are authorized to decide should not be summarily taken from them and submitted to a court without first giving such administrative agency the opportunity to dispose of the same after due deliberation. Doctrine of fair comment. A doctrine in the law of libel, which means that while in general every discreditable imputation publicly made is deemed false, because every man is presumed innocent until his guilt is judicially proved, and every false imputation is directed against a public person in his public capacity, is not necessarily actionable. In order that such discreditable imputation to a public official may be actionable, it must either be a false allegation of fact or a comment based on a false supposition. If the comment is an expression of opinion based on established facts, then it is immaterial that the opinion happens to be mistaken as long as it might reasonably be inferred from the facts. Borhal versus CA. Doctrine of finality of judgment. The doctrine that once a judgment attains finality, it thereby becomes immutable and unalterable. It may no longer be modified in any respect, even if the modification is meant to correct what is perceived to be an erroneous conclusion of fact or law, and regardless of whether the modification is attempted to be made by the court rendering it or by the highest court of the land. Just as the losing party has the right to file an appeal within the prescribed period, the winning party also has the correlative right to enjoy the finality of the resolution of his case. The doctrine of finality of judgment is grounded on fundamental considerations of public policy and sound practice, and that, at the risk of occasional errors, the judgments or orders of courts must become final at some definite time fixed by law. Otherwise, there would be no end to litigations, thus setting to naught the main role of courts of justice, which is to assist in the enforcement of the rule of law and the maintenance of peace and order by settling justifiable controversies with finality. Gallardo, Coro versus Gallardo. Doctrine of forum nonconvenience. It's a Latin word that means the forum is inconvenient. A rule designated to deter the practice of global forum shopping, kokyain na killing, pangalangan, conflicts of law. This is to prevent non-resident litigants from choosing the forum or place wherein to bring their suit for malicious reasons such as to secure procedural advantages, to annoy and harass the defendant, to avoid overcrowded dockets, or to select a more friendly venue. Under this doctrine, a court in conflicts of law cases may refuse imposition on its jurisdiction where it is not the most convenient or available forum and the parties are not precluded from seeking remedies elsewhere. Doctrine of hierarchy of courts. An established policy that parties must observe the hierarchy of courts before they can seek relief directly from the Supreme Court. The rationale for this rule is twofold. One, it would be an imposition upon the limited time of the Supreme Court, and B, it would inevitably result in a delay, intended or otherwise, in the adjudication of cases which, in some instances, had to be remanded or referred to the lower court as the proper form under the rules of procedure, or as better equipped to resolve the issues because the Supreme Court is not a trial of facts. Years of Hinog versus Melicor. Doctrine of governmental immunity from suit. The doctrine that no governmental body can be sued unless it gives permission to it. Doctrine of holding out. Also, the doctrine of agency by estoppel. The doctrine where the principal will be stopped from denying the grant of authority if third parties have changed their positions to their detriment in reliance on the representations made. Doctrine of holdover. The doctrine under which a public officer whose term has expired or services have been terminated is allowed to continue holding his office until his successor is appointed or chosen and had qualified. Doctrine of immunity from suit, the application of which has been restricted to sovereign or governmental activities, jure imperii. The mantle of state immunity cannot be extended to commercial, private, and proprietary acts, jure gestionis. Number two, the restrictive application of state immunity is proper when the proceedings arise out of commercial transactions of the foreign sovereign, its commercial activities or economic affairs. Stated differently, a state may be said to have descended to the level of an individual and thus can be deemed to have tacitly given its consent to be sued only when it enters into business contracts. It does not apply where the contract relates to the exercise of its sovereign functions. U.S. v. Rees, GR 35645. Doctrine of immutability and unalterability of a final judgment exceptions from a case decided in 2008. 1. The correction of clerical errors. 2. The so-called nunc pro tunc entries that cause no prejudice to any party. And 3. Void judgments. And 4. Whether circumstances transpire after the finality of the decision rendering its execution unjust and inequitable. Temic Semiconductors Incorporated Employees Union versus Federation of Free Workers, GR 160993, May 20, 2008. Doctrine of implication. That which is plainly implied in the language of a statute is as much as part of it as that which is expressed. Doctrine of implied municipal liability. A municipality may become obligated upon an implied contract to pay the reasonable value of the benefits accepted or appropriated by it, as to which it has the general power to contract. Province of Cebu versus IAC. Doctrine of implied trust. The doctrine enunciated in Article 1456 of the Civil Code, which provides that if property is acquired through mistake or fraud, the person obtaining it by force of law considered a trustee of an implied trust for the benefit of the person from whom the property comes. Armamento versus Guerrero, GR 34228. Doctrine of in pari delicto. Legal principle that if two parties in a dispute are equally at fault, then the party in possession of the contested property gets to retain it, and the courts will not interfere with the status quo. It implies that if a party whose action or failure to act precipitates breach of a contract, or who fails to take appropriate action or takes inappropriate action to limit or recoup a loss, such party may not claim nor be awarded damages. Doctrine of inappropriate provision. It deals with an item provision in a budget bill that are to be treated as items for the president's veto power. Doctrine of incompatibility of public offices. It concerns a potential clash of two incompatible public offices held by a single official. In other words, the doctrine concerns a conflict between an individual's performance of potentially overlapping public duties. Doctrine of incorporation in international law. The doctrine that states that the rules of international law form part of the law of the land and no legislative action is required to make them applicable to a country. The Philippines follows this doctrine because Section 2, Article 2 of the Constitution states that the Philippines adopts the generally accepted principles of international law as part of the law of the land. Doctrine of indivisibility of torrens titles. A certificate of title, once registered, should not thereafter be impugned, altered, changed, modified, enlarged, or diminished except in a direct proceeding permitted by law. Doctrine of indelible allegiance. The doctrine that an individual may be compelled to retain his original nationality notwithstanding that he has already renounced or forfeited it under the laws of the second state whose nationality he has acquired. Doctrine of informed consent, a duty imposed on a doctor to explain the risks of recommended procedures to a patient before a patient determines whether or not he or she should go forward with the procedure. Doctrine of interlocking confessions under evidence. The doctrine under which extrajudicial confessions independently made without collusion, which are identical with each other in their essential details and are corroborated by other evidence on record, are admissible as circumstantial evidence against the person implicated to show the probability of the latter's actual participation in the commission of the crime. People versus Moleda. Doctrine of inverse condemnation. It involves the action to recover just compensation from the state or its expropriating agency. It has the objective to recover the value of property taken in fact by the governmental defendant, even though no formal exercise of the power of eminent domain has been attempted by the taking agency. Napocor versus Ears of Sangkay. Doctrine of judicial admissions. The well settled doctrine that judicial admissions cannot be contradicted by the admitter, who is the party himself and binds the person who makes the same, and absent any showing that this was made through palpable mistake, no amount of rationalization can offset it. Binarao versus Plus Builders. Doctrine of judicial stability. The doctrine that no court can interfere by injunction with the judgments or orders of another court of concurrent jurisdiction having the power to grant the relief sought by the injunction. Kabili versus Balindong, decided in 2011. Doctrine of judicial supremacy. The doctrine recognizing that the judiciary is vested with the power to annul the acts of either the legislative or the executive or both when not conformable to the fundamental law. The power of judicial review under the Constitution, Angara versus Electoral Commission, 63 Phil 139. Doctrine of jus sanguinis, a Latin word means right of blood, a principle of nationality by which citizenship is not determined by place of birth but by having instead one or both parents who are citizens of the state, or more generally by having state citizenship or membership to a nation determined or conferred by ethnic, cultural, or other descent or origin. Doctrine of jus soli, Latin word means right of the soil. The doctrine recognizing the right of anyone born in the territory of a state to nationality or citizenship. Doctrine of laches, also known as the doctrine of stale demands. 1. A doctrine based upon grounds of public policy which requires for the peace of society the discouragement of stale claims and is principally a question of the iniquity or unfairness of permitting a right or claim to be enforced or asserted. Tiham versus Sibong Hanoi. Number 2. The time-honored rule anchored on public policy that relief will be denied to a litigant whose claim or demand has become stale, or who has acquiesced for an unreasonable length of time, or who has not been vigilant or who has slept on his rights either by negligence, folly, or inattention. Arandaza versus CA. Doctrine of lack of capacity to sue. The doctrine of lack of capacity to sue based on failure to first acquire a local license is based on considerations of public policy. It was never intended to favor nor insulate from suit unscrupulous establishments or nationals in case of breach of valid obligations or violations of legal rights of unsuspecting foreign firms or entities simply because they are not licensed to do business in the country. Facilities Management Corporation versus De La Osa. Doctrine of last clear chance, also known as the doctrine of discovered peril or the humanitarian doctrine. A doctrine in the law of torts which states that the contributory negligence of the party injured will not defeat the claim for damages if it is shown that the defendant might, for the exercise of reasonable care and prudence, have avoided the consequences of the negligence of the injured party. In such cases, the person who had the last clear chance to avoid the mishap is considered, in law, solely responsible for the consequences thereof. Ong versus Metropolitan Water District. Doctrine of legal entity of the separate personality of the corporation. The doctrine that a corporation may not be made to answer for acts and liabilities of its stockholders or those of legal entities to which it may be connected or vice versa. Panay versus Clave. Doctrine of liberal construction of retirement laws. The doctrine that retirement laws are liberally construed and administered in favor of the persons intended to be benefited. All doubts as to the intent of the law should be resolved in favor of the retiree to achieve its humanitarian purposes. Borromeo versus CSC. Doctrine of limited liability. The ship agent shall also be civilly liable for the indemnities in favor of third persons, which may arise from the conduct of the captain in the care of the goods which he loaded on the vessel, but he may exempt himself therefrom by abandoning the vessel with all the equipments and the freight it may have earned during the voyage. Code of Commerce Yanko versus Lasema. Doctrine of lis pendens. Latin word means a pending suit. The jurisdiction, power of control, which a court acquires over the property involved in the suit pending the continuance of the action and until final judgment thereunder. Doctrine of loss of confidence. Requisites. 1. Loss of confidence should not be simulated. 2. It should not be used as a subterfuge for causes which are improper, illegal, or unjustified. 3. It may not be arbitrarily asserted in the face of overwhelming evidence to the contrary. 4. It must be genuine, not a mere afterthought to justify an earlier action taken in bad faith. And 5. The employee involved holds a position of trust and confidence. Be the Stutch Food Corporation versus NLRC. Doctrine of malicious prosecution. The doctrine that pertains to persecution through the misuse or abuse of judicial processes or the institution and pursuit of legal proceedings for the purpose of harassing, annoying, vexing, or injuring an innocent person. Villanueva versus UCPB, GR 138291. Doctrine of management prerogative. The doctrine under which every employer has the inherent right to regulate according to his own discretion and judgment all aspects of employment, including hiring, work assignments, working methods, the time, place, and manner of work, work supervision, transfer of employee, layoff of workers, and discipline, dismissal, and recall of employees. Rule Bank of Cantillan versus Julve. Doctrine of mortgagee and good faith. The rule that all persons dealing with property covered by a torrent certificate of title as buyers or mortgagees are not required to go beyond what appears on the face of the title. The public interest in upholding the indefeasibility of a certificate of title as evidence of the lawful ownership of the land or of any encumbrance thereon, protects a buyer or mortgagee who in good faith relied upon what appears on the face of the certificate of title. Doctrine of mutuality of remedy, a civil law doctrine founded on the idea that one party should not obtain from equity that which the other party could not obtain. Doctrine of necessary implication, the doctrine which states that what is implied in a statute is as much as part thereof as that which is expressed. National Association of Trade Unions versus Torres. Doctrine of non-delegation. 1. The principle that delegated power constitutes not only a right but a duty to be performed by the delegate through the instrumentality of his own judgment and not through the intervening mind of another. 2. The recognized exceptions to this principle are as follows. 1. Delegation of tariff powers to the President under Section 28, Article 6 of the Constitution. 2. Delegation of emergency powers to the President under Section 23, Article 6 of the Constitution. 3. Delegation to the people at large. And 4. Delegation to local governments. And 5th, delegation to administrative bodies. Abacada Guru Party, List versus Ermita. Doctrine of non-interference under remedial law, an elementary principle of higher importance in the administration of justice, that the judgment of a court of competent jurisdiction may not be opened, modified, or vacated by any court of concurrent jurisdiction. Doctrine of non-suability, the basic postulate enshrined in the Constitution that the state may not be sued without its consent, which reflects nothing less than a recognition of the sovereign character of the state and an express affirmation of the unwritten rule, effectively insulating it from the jurisdiction of courts. It is based on the very essence of sovereignty. DA versus NLRC. Doctrine of operative fact, the doctrine that nullifies the effects of an unconstitutional law by recognizing that the existence of a statute prior to a determination of unconstitutionality is an operative fact and may have consequences which cannot always be ignored. The past cannot always be erased by a new judicial declaration. It is applicable when a declaration of unconstitutionality will impose an undue burden on those who have relied on the invalid law. Planters Products versus Fertifil. Doctrine of ostensible agency. As reiterated in another case, the doctrine which imposes liability not as a result of the reality of a contractual relationship, but rather because of the actions of a principal or an employer in somehow misleading the public into believing that the relationship or the authority exists. Professional Services Incorporated versus Agana. Doctrine of outside appearance, the doctrine which states that a corporation is bound by a contract entered into by an officer who acts without or in excess of his actual authority in favor of a person who deals with him in good faith, relying on such apparent authority. Doctrine of overbreadth, an exemption to the prohibition against third-party standing. The doctrine permits a person to challenge a statute on the ground that it violates the free speech rights of third parties not before the court, even though the law is constitutional as applied to that defendant. In other words, the overbreadth doctrine provides that, given a case of controversy, a litigant whose own activities are unprotected may nevertheless challenge the statute by showing that it substantially abridges the free speech rights of other parties not before the court. Doctrine of parens patriae, father of his country. The doctrine referring to the inherent power and authority of the state to provide protection of the person and property of a person non sui juris. Under that doctrine, the state has the sovereign power of guardianship over persons under disability. Thus, the state is considered the parens patriae of minors. Doctrine of pari delicto, the doctrine under which no recovery can be made in favor of the plaintiffs for being themselves guilty of violating the law. Ponce versus CA. Doctrine of part performance. An equitable principle that allows a court to recognize and enforce an oral contract despite its legal deficiencies and provides a way around the statutory bar to the enforcement of an oral contract. By applying the doctrine, a party can establish the existence of a contract despite the lack of any written evidence. Generally, without written evidence, a contract does not satisfy the formal requirements set by the legislature under the statute of frauds. The doctrine is an exception to this as it allows failure to comply with the statute of frauds to be overcome by a party's execution in reliance on an opposing party's oral promise of an oral contract's requirements. Doctrine of political question. The well-settled doctrine that political questions are not within the province of the judiciary except to the extent that power to deal with such questions has been conferred upon the courts by express constitutional or statutory provisions. Doctrine of prejudicial question. The doctrine that comes into play generally in a situation where civil and criminal actions are pending and the issue involved in both cases are similar or so closely related that an issue must be preemptively resolved in the civil case before the criminal action can proceed. Thus, the existence of a prejudicial question in a civil case is alleged in the criminal case to cause the suspension of the latter pending final determination of the former. Quiambao versus Osorio. Doctrine of presumed identity approach, also called the doctrine of processual presumption, where a foreign law is not pleaded or even if pleaded is not proved. The presumption is that foreign law is the same as ours. Doctrine of presumption of regularity in the performance of official duty. The doctrine holding that every public official, absent any showing of bad faith and malice, is entitled to the presumption regularity in the performance of official duties. Doctrine of primary jurisdiction. The doctrine that holds that if the case is such that its determination requires the expertise, specialized skills and knowledge of the proper administrative bodies because technical matters or intricate questions of facts are involved, then relief must first be obtained in an administrative proceeding before a remedy will be supplied by the courts even though the matter is within the proper jurisdiction of a court. Doctrine of prior restraint. The doctrine concerning official governmental restrictions on the press or other forms of expression in advance of actual publication or dissemination. Doctrine of prior use. The principle that prior use of a trademark by a person, even in the absence of prior registration, will convert a claim of legal appropriation by subsequent users. Doctrine of privileged communication. 1. The doctrine that utterances made in the course of judicial proceedings, including all kinds of pleadings, petitions, and motions, belong to the class of communications that are absolutely privileged. U.S. versus Salera. Number 2. The doctrine that statements made in the course of judicial proceedings are absolutely privileged, that is, privileged regardless of defamatory tenor and of the presence of malice, if the same are relevant, pertinent, or material to the cause in hand, or subject to inquiry. Tolentino versus Bilosis. Doctrine of privity of contract. Doctrine that provides that a contract cannot confer rights or impose obligations arising under it on any person or agent except the parties to it. The basic premise is that only parties to contracts should be able to sue to enforce their rights or claim damages as such. Doctrine of pro reo. The doctrine that where the evidence on an issue of fact is in question or there is doubt on which side the evidence weighs, the doubt should be resolved in favor of the accused. People versus Abarquez. Doctrine of promissory estoppel. The doctrine under which an estoppel may arise from the making of a promise, even though without consideration, if it was intended that the promise should be relied upon, and in fact it was relied upon, and if a refusal to enforce it would be virtually to sanction the perpetration of fraud or would result in utter injustice. In this respect, The reliance by the promisee is generally evidenced by action or forbearance on his part, and the idea has been expressed that such action or forbearance would reasonably have been expected by the promiser. Mere omission by the promisee to do whatever the promiser promised to do has been held insufficient forbearance to give rise to a promissory estoppel. Ramos versus Central Bank of the Philippines. Doctrine of proper submission. All the proposed amendments to the Constitution shall be presented to the people for their ratification or rejection at the same time, not piecemeal. Number 2. Plebiscite may be held on the same day as a regular election provided that people are sufficiently informed of the amendments to be voted upon, to conscientiously deliberate thereon, to express their will in a genuine manner. All the amendments must be submitted for ratification at one plebiscite only. The people have to be given a proper frame of reference in arriving at their decision. They have no idea yet of what the rest of the amended Constitution would be. Tolentino versus Comelect. Doctrine of protection against compulsory disclosures. The doctrine that no person could be compelled to testify against himself or to answer any question which would have had a tendency to expose his property to a forfeiture or to form a link in a chain of evidence for that purpose, as well as to incriminate him. Doctrine of proximate cause. The doctrine stating that proximate legal cause is that acting first in producing the injury, either immediately or by settling other events in motion, all constituting a natural and continuous chain of events, each having a close causal connection with its immediate predecessor, the final event in the chain immediately affecting the injury as a natural and probable result of the cause which first acted, under such circumstances that the person responsible for the first event should, as an ordinary prudent and intelligent person, have reasonable ground to expect at the moment of his act or default that an injury to some person might probably result therefrom. Doctrine of public policy. The doctrine under which is applied to the law of contracts. Courts of justice will not recognize or uphold a transaction when its object, operation, or tendency is calculated to be prejudicial to the public welfare, to sound morality, or to civic honesty. Doctrine of purposeful hesitation. The doctrine that charges every court, including the Supreme Court, with the duty of a purposeful hesitation before declaring a law unconstitutional, on the theory that the measure was first carefully studied by the executive and legislative departments and determined by them to be in accordance with the fundamental law before it was finally approved. Drilon versus Lee. Doctrine of qualification. The process of deciding whether or not the facts relate to the kind of question specified in a conflict rule. The purpose of characterization is to enable the court of the forum to select the proper law. Agpalo. Doctrine of qualified political agency. The doctrine which holds that as the president cannot be expected to exercise his control powers all at the same time and in person, he will have to delegate some of them to his cabinet members, who in turn, by his authority, control the bureaus and other offices under their respective jurisdiction in the executive department. Carpio versus Executive Secretary, GR 96409. Doctrine of quantum merit. It's a Latin word that means as much as one deserves. The doctrine that prevents undue enrichment based on the equitable postulate that it is unjust for a person to retain benefit without paying for it. Doctrine of ratification in agency. The doctrine pertaining to the adoption or confirmation by one person of an act performed on his behalf by another without authority. The substance of the doctrine is confirmation after conduct, amounting to a substitute for a prior authority. Manila Memorial Park Cemetery versus Linsangan. Doctrine of rational equivalence. The reasonable necessity of the means employed to repel the unlawful aggression does not imply material commensurability between the means of attack and defense, but what the law requires is rational equivalence, in the consideration of which will enter the principal factors of the emergency, the imminent danger to which the person attacked is exposed, and the instinct, more than the reason, that moves or impels the defense, and the proportionateness thereof does not depend upon the harm done, but rests upon the imminent danger of such injury. People versus Gutual, 324, Field 244. Doctrine of relations back. That principle of law by which an act done at one time is considered by a fiction of law to have been done at some antecedent period. It is a doctrine which, although of equitable origin, has a well recognized application to proceedings at law, a legal fiction invented to promote the ends of justice or to prevent injustice and the occurrence of inquiries where otherwise there would be no remedy. The doctrine, when invoked, must have connection with actual fact, must be based on some antecedent lawful rights. It has also been referred to as the doctrine of relation back. Allied Banking Corporation versus CA. Doctrine of renvoi, refer back. The process by which a court adopts the rules of a foreign jurisdiction with respect to any conflict of laws that arises. In some instances, the rules of the foreign state might refer to the court back to the law of the forum where the case is being heard. Doctrine of res gestae. Latin word means things done. Doctrine that is a recognized exception to the rule against hearsay evidence based on the belief that because certain statements are made naturally, spontaneously, and without deliberation during the course of an event, they leave little room for misunderstanding or misinterpretation upon hearing by someone else, that is, by the witness who will later repeat the statement to the court, and thus the courts believe that such statements carry a high degree of credibility. Doctrine of res ipsa loquitur. Latin means the thing itself speaks. A doctrine of law that one is presumed to be negligent if he had exclusion control of whatever caused the injury, even though there is no specific evidence of an act of negligence, and without negligence, the accident would not have happened. And the doctrine of res judicata. The doctrine has two aspects. The first is the effect of a judgment as a bar to the prosecution of a second action upon the same claim, demand, or cause of action. The second aspect is that it precludes the relitigation of a particular fact or issues in another action between the same parties on a different claim or cause of action. Doctrine of res spirit domino. It means the thing is lost to the owner. The doctrine that states that when a thing is lost or destroyed, it is lost to the person who was the owner of it at that time. Doctrine of respondeat superior. Let the master answer. A legal doctrine which states that in many circumstances, an employer is responsible for the actions of employees performed within the course of their employment. Doctrine of ripeness for judicial review. This doctrine determines the point at which courts may review administrative action. The basic principle of ripeness is that the judicial machinery should be conserved for problems which are real and present or imminent, and should not be squandered on problems which are future, imaginary, or remote. Doctrine of secondary meaning. The doctrine under which a word or phrase originally incapable of exclusive appropriation with reference to an article in the market, because geographical or otherwise descriptive, might nevertheless have been used so long and so exclusively by one producer with reference to this article, that in that trade and to that group of the purchasing public, the word or phrase has come to mean that the article was his produce. Ang versus Chidoro. Doctrine of self-help. The doctrine enunciated in Article 429 of the Civil Code, which provides the owner or lawful possessor of a thing has the right to exclude any person from the enjoyment and disposal thereof. For this purpose, he may use such force as may be reasonably necessary to repel or prevent an actual or threaten unlawful physical invasion or usurpation of his property. Doctrine of separability. The doctrine that enunciates that an arbitration agreement is an independent of the main contract. The arbitration agreement is to be treated as a separate agreement, and the arbitration agreement does not automatically terminate when the contract of which it is part comes to an end. Gonzalez versus Climax Mining Limited, June 22, 2007. Doctrine of separation of church and state. The doctrine enshrined in Section 6, Article 2 of the 1987 Constitution, which provides that the separation of church and state shall be inviolable. The idea advocated by this principle is to delineate the boundaries between the two institutions and thus avoid encroachments by one against the other because of a misunderstanding of the limits of their respective exclusive jurisdictions. Doctrine of separation of powers, a basic postulate that forbids one branch of government to exercise powers belonging to another co-equal branch, or for one branch to interfere with the other's performance of its constitutionally assigned functions. Doctrine of shifting majority. For each House of Congress to pass a bill, only the votes of the majority of those present in the session, there being a quorum, is required. Doctrine of sole and exclusive competence of the labor tribunal. The doctrine that recognizes the labor arbiter's exclusive jurisdiction to hear and decide the following cases involving all workers, whether agricultural, non-agricultural: 1. Unfair labor practice cases; 2. Termination disputes; 3. If accompanied with a claim for reinstatement, those cases that workers may file involving wages, rate of pay, hours of work, and other terms and conditions of employment. 4th, claims for actual, moral, exemplary, and other forms of damages arising from the employer-employee relations. 5. Cases arising from any violation of Article 264 of the Labor Code, including questions involving the legality of strikes and lockouts. And 6. Except claims for employees' compensation, Social Security, Medicare, and maternity benefits. All other claims arising from employer-employee relations, including those of persons in domestic and household service, involving an amount exceeding $5,000, whether or not accompanied with a claim for reinstatement. Article 217 of the Labor Code. Doctrine of strained relations under labor. The rule that where reinstatement is not feasible, expedient, or practical, as where reinstatement would only exacerbate the tension and strained relations between the parties, or where the relationship between the employer and the employee has been unduly strained by reason of their irreconcilable differences, particularly where the illegally dismissed employee held a managerial or key position in the company, it would be more prudent to order payment of separation pay instead of reinstatement. Quijano versus Mercury Drug Corporation. Doctrine of subrogation. The principle that covers a situation wherein an insurer who has paid a loss under an insurance policy is entitled to all the rights and remedies belonging to the insured against a third party with respect to any loss covered by the policy. It contemplates full substitution such that it places the party subrogated in the shoes of the creditor, and he may use all means that the creditor could employ to enforce payment. Keppel Cebu Shipyard versus Pioneer Insurance and Surety Corporation.